If you hire the tax law offices of David W. Clausing to help you with your collection issues, the first thing we're going to try and do is gain the high ground in the collection matter. We want to, if possible, take the power away from the IRS, the revenue officer, or the automated collections department and put the power in your corner. Slow the game down, make wise choices, and come up with the best possible solutions for you. If we don't get this opportunity, you're dancing to the tune of the government rather than trying to work with the government to reach a solution that works for both parties. So to gain control of your matter, we basically have 3 appeals programs that we can choose from. Each has advantages and disadvantages. The first one we're going to discuss is called a CDP appeal, or a collection due process hearing. The second we're going to discuss is called an equivalency hearing. The third is going to be a CAP appeal. A CAP is a collection appeal program. Okay, so let's first talk about collection due process hearings. In order to request a collection due process hearing, the taxpayer needs to file Form 12153, which is a request for a collection due process hearing. You must do this within the 30 days of receiving the IRS's final intent to levy notice. The first thing this does for us as your attorney, as your law firm, is it protects the specified tax periods enumerated on the final intent to notice document from further collection action until your appeal is heard. It freezes the collection department. This can be a freeze for up to 2 months, in which time we have time to get your house in order, time the revenue officer oftentimes won't be willing to grant to you, that we can make your case in appeals. In order to get a lot of these appeals options in place, we have to have you in full compliance. A lot of times the revenue officer has lost patience with you. They've given you notice after notice, and for some reason you haven't managed to get in compliance. The time ticking for the 2 months can give us the chance to get you in full compliance so that when we do face appeals, we can get you a better resolution to your matter than the revenue officer was offering you. The cold hard fact of the matter here is if you owe more than $50,000 to the IRS, they do not have to grant you an installment agreement. They can resort to aggressive collection action, including levies against any asset that is liquid. First thing they look to is cash accounts. They can look to retirement accounts, they can look to your Social Security, they can look to, if you have 4 cars, 3 of them are collector's editions, they can grab those cars and sell them at auction and take that money. If you have a boat and that's an asset they could grab. There's lots of things they can do, and you may not be happy about it. Sometimes the only way to stop the revenue officer from taking an action that you don't agree with is to tie their hands procedurally by taking it away from the revenue officer and taking it to the appeals department. Kind of shuffles the deck. The second thing that filing a collection due process hearing does for you is it secures the right to take your issue to court if you don't agree with the deal that you strike with the appeals department concerning your collection action. If appeals says we're going to take your assets and you don't want them taking your assets, you may be able to get a better deal by taking it higher up the ladder to a court. One big negative thing that a collection due process hearing does is it freezes the 10-year collection statute. Ordinarily, the IRS has 10 years to collect an outstanding debt from you. If it isn't paid within those 10 years, unless they reduce that amount to judgment, it becomes non-collectible at that point. If you file a CDP, that 10-year statute freezes while they're considering your appeal. Until it bounces out of appeals back into collections, that 10-year clock isn't running. When you finally get to appeals, your attorney needs to make all arguments as to why they disagree with the proposed action of the revenue officer and what collection alternatives would work for both the government and the taxpayer. In other words, what are your proposed collection alternatives? When you get to appeals to argue the collection issues, if you can't reach resolution with appeals, they're going to issue a notice of determination. At that point, after receiving the notice of determination, you have 30 days to file a tax court petition in order to move the collection issue out of appeals and into a court. Now, if you get nothing else out of this video, The failure to file a collection due process appeal or hearing within that 30-day window causes lots of problems. Number one, you lose the right to take your issue to federal court if you disagree with the resolution reached in appeals. You lose the opportunity to temporarily tie the hands of an overly aggressive, sometimes, in my opinion, abusive revenue officer and gain the high ground. You can lose the ability to negotiate a more palatable collection option. In other words, you might have to take what that revenue officer is demanding rather than reaching an agreement that's more palatable to you. Keep in mind the $50,000 complication. If you owe more than $50,000, the government doesn't have to give you a lot of the collection options. They have the high ground to dictate the collection options that they want, not the collection options that are acceptable to you. To get the best result, you really need a tax attorney in situations where you owe over $50,000. The next way an attorney can attempt to take control over your collection issue is through an equivalency hearing. Ordinarily, our office prefers CAP appeals or CDP appeals over equivalency hearings, and I'll explain why. If you file a CDP appeal and it happens to be after the 30-day notice period is run, you're automatically bumped into the equivalency hearing procedures. To qualify for an equivalency hearing, you need to be after 30 days from the issuance of that final intent to levy notice, but within 1 year from the issuance of that final intent to levy notice. When you're granted an equivalency hearing, the case will still be forwarded to appeals, but there are some distinct differences. I find them advantageous, so do most tax attorneys, as opposed to other procedures. The biggest disadvantage with an equivalency hearing is that the revenue officers or automated collections department's hands are not tied while the appeal is being heard. This can be up to a 2-month time period before they even hear your appeal. During that time period, that 2 months or longer, that revenue officer is free to bring forward any collection alternative they desire, including grabbing your assets, selling them, posting up public liens, entering into wage garnishments, which your employer gets knowledge of. By the way, liens are public notice. It'll affect your credit rating. Lots of bad things can happen. This is why it's so important to file within that 30-day period and get a CDP procedure rather than an equivalent hearing. An equivalency hearing is normally granted fairly quickly. When you get there, you better make sure your house is in order, that you're in full compliance with the law, that you've got all the information that the appeals officer is going to need to see to decide in your favor, because you really don't have the high ground, and that appeal officer knows that if you don't like what they have to hand you, you have no tax court or any type of jurisdiction of a court to take it to. Appeals word is final. They tend to not work as well with you when you don't have the high ground. When you get to appeals, they're going to check your record of compliance. They're going to check that you've provided all the information they need to make a timely decision, and then they will consider your alternative collection methodology, but they may not grant it. If you go to appeals again and you don't like what they're giving you, you have no right to go to court, and as soon as appeals issues a decision, you're back down to the revenue officer or automated collections department that you were dealing with prior to filing the appeal hearing. One positive thing to say for an equivalency hearing is that unlike a CDP appeal, the 10-year clock does not get stopped during the period where appeals is considering your position. The last action that an attorney can take to try and grab the high ground in a collection action is a collection appeal program request. I can use a collection appeal program request to appeal many of the collection actions desired to be taken by the IRS that you find unpalatable. The way you go about requesting a CAP appeal is by filing Form 9423. The collection actions taken or being proposed by the IRS that can be appealed via the CAP procedures are as follows. A notice of federal tax lien that is about to be or has been posted to the public record. A levy against your bank account or other property that has been or soon will be taken. a seizure of your property, where the government grabs the property from you with the intent to sell it either at auction or some other methodology. You can sometimes recoup that property through this procedure. This procedure can be used to subordinate a lien or to request a withdrawal of a public lien. This procedure can be used to request to issue lien certificates, such as a lien subordination, a lien withdrawal, or a lien discharge, or non-attachment of a lien, especially when this has been denied. This procedure can be used to attack a proposed or actual rejection or a modification or termination of an existing installment agreement. Finally, it can be used to go after a wrongful levy. An attorney must make his taxpayer comply with certain procedures before utilizing a cap. This differs depending upon whether the client is in front of a revenue officer or in front of automated collection services. If the taxpayer is in front of an RO, he is required to do the following. The first required action is to inform the revenue officer that you disagree with their proposed collection action and you're going to appeal that decision. The taxpayer is required to explain why they disagree with the proposed action and offer alternative solutions. If the issue can't be resolved directly with the RO, the taxpayer or his representative must escalate the issue to the RO's manager. After speaking with the auditor's manager, the taxpayer and his representative have 48 hours to file the Form 9423 to get into the collection appeal program. If the taxpayer is appealing the rejection of a proposed installment agreement or the proposed cancellation of the existing installment agreement, they're required to do the following. The taxpayer has 30 days to file Form 9423 after receiving notice from the IRS that they are rejecting the proposed installment agreement. The taxpayer has 76 days to file 9423 after receiving notice that the IRS intends to terminate an existing installment agreement. In any case, the installment agreement in existence will terminate within 45 days of the notice of intent to terminate the installment agreement.